Guess what? The Laundries are once again asking the court to throw out the Petito's lawsuit. So I'm going to walk you through the motion to dismiss that was just filed by the Laundries. And I'm also going to explain what's next. So is it a slippery slope for the Constitution or a valid lawsuit by grieving parents? Hi there, I'm Michele Hagan. I'm a legal analyst and a former prosecutor. You may recognize me because I provided a lot of legal analysis for the Elizabeth Holmes case and several videos on the Petito versus Laundrie lawsuit that you might want to check out before you watch this video. So this video is simply my opinion. It's for education and informational purposes. So please do leave a comment. I want to know what's your analysis. What do you think? So let me give you a little background. So Gabby Petito was murdered by Brian Laundrie. So Gabby's parents are suing Brian's parents for intentional infliction of emotional distress because they claim the Laundries withheld information regarding the whereabouts and the death of their daughter, Gabby Petito. It's a terrible, terrible tragedy. Terrible tragedy. And the Petitos want to be compensated for the emotional distress that they claim was caused by the Laundries withholding information regarding their daughter and her death, her tragic death by Brian Laundrie. So let's take a look at their motion to dismiss, and you make the call. Do you think it's a slippery slope for the Constitution, or do you think it's a valid lawsuit by grieving parents? I mean, it's very sad. I mean, both families lost their children. So let's take a look at the motion to dismiss. So here it is. It was filed last Friday, Friday the 13th, and it's Joseph Petito, which is Gabby's father, and Nichole Schmidt, Gabby's mother, are suing Christopher Laundrie and Roberta Laundrie, which is Brian's parents, for allegedly withholding information and causing them emotional distress regarding the death, the murder of their daughter, Gabby Petito. So once again, the Laundries want the court to throw out the Petito's lawsuit because it failed to state a cause of action. There are no facts, they claim, that could support the cause of action, and the court should dismiss the complaint with prejudice. So this is all the background. You can go ahead and read it, and I covered this in my prior videos. You can look at the Petitos changed their lawsuit video. Also the video I did dismissing the Petito versus Laundrie lawsuit, and the other video I did regarding don't dismiss the Petito versus Laundrie lawsuit. And again, it'll be in the playlist. So what is it that the Laundries now claim gives the court justification to dismiss the Petito's lawsuit? So they're saying it doesn't state a cause of action. The four corners, remember, I talked about this before in a prior video. The Petitos have to allege enough facts in the four corners of that complaint to withstand a motion to dismiss. In other words, to allege enough facts to support a cause of action for intentional infliction of emotional distress. The Laundries are saying here, even if you take everything that they put in their four corners of that complaint, it doesn't amount to a cause of action for emotional distress. Okay, so if you read through this, and I'm going to get to the part that's new. And again, they say while the Petitos allege some facts, those facts could never establish a claim for emotional distress. Okay, they're saying these are just, I'm highlighting areas that are different than the initial complaint filed, or I should say, that are different than the initial motion to dismiss, because this is the second one now. This one's based on the Laundries asking the court to dismiss the amended complaint. In other words, the new complaint, right? So I'm just going to scroll through this. You can go ahead and read it. They talk about the 5 allegations that characterize as outrageous. One of the elements of intentional infliction is you have to show that the Laundrie's conduct was outrageous. So here are the 5 allegations that the Petitos allege that the Laundries did, which amount to emotional distress. 1, failing to advise the Petitos that Gabby Petito was deceased. 2, failing to disclose to the Petitos the location of Gabby's body. Taking a family vacation with their son who had murdered Gabby Petito. I mean, this is all very sad. While the parents were desperately seeking her whereabouts, blocking access to their cell phone and Facebook page, and the Laundrie's attorney issuing a statement to the press expressing hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family, knowing that Gabby Petito was deceased. It's a terrible, terrible tragedy. Okay, so we're going to get to the part here. So again, they're saying that the Laundrie's act of doing nothing other than maintaining their privacy and silence is enough to subject them to a supposed cause of action that there would be, if they were subjected to this lawsuit, they're claiming, the Laundries are claiming, there would be virtually no limitation on the tort of emotional distress and the fundamental right to remain silent. Because if you remember, the Laundries are claiming that one of the reasons that the Petitos lawsuit should be thrown out is because the Laundries were just exercising their constitutional rights. 1, to remain silent, to speak or not to speak. Secondly, the right to obtain counsel, right? The right to remain silent, which are all constitutional rights. And so what the Laundries are claiming in this motion to dismiss is that if the court allows this case to proceed, then they're basically trampling on the constitutional rights. And I'm calling it a slippery slope for the Constitution. Possibly, right? So the plaintiff's cause of action is novel. And I called this out in one of the earlier videos. I said, and I think I said it in the live stream, the last live stream I did, was that this lawsuit is basically a test case. It's testing the law. It's testing the law on whether or not parents or anyone can exercise their constitutional rights when they're in this kind of a situation, whether they have an obligation to speak, to disclose the whereabouts, to disclose any information that they may know. So they point out, the Laundries point out, that the plaintiffs have cited no cases. In other words, there's no case law to support their claim that parents, that Brian's parents, the Laundries, have an obligation or had an obligation to tell the Gabby's parents what they knew about Gabby's whereabouts, what happened, whether or not Brian had advised them he murdered her, whether or not they even had an obligation to speak to the Petitos. That's what this lawsuit is testing, whether or not the Constitution allows them to remain silent or whether the Laundries have an obligation to speak. So they're saying the plaintiffs haven't cited any cases. Well, because there isn't any case law on this. If this case proceeds forward, this will be setting precedent. This will be setting potentially case law. And whether or not it would require any person and their family to speak about an alleged crime or other tragic event. Indeed, the slippery slope of allowing this cause of action to proceed would require anyone with knowledge of events that are hurtful or which cause emotional distress to convey their knowledge or be exposed to liability. Why declining to speak or communicate about Gabby's death is undoubtedly tragic, and her parents deserve sympathy. However, a parent's grief caused by the disappearance and the ultimate loss of a child does not create a cause of action. So they're saying, number 1, there's no case law to support this cause of action. Number 2, a parent's grief, how tragic this is, does not support a cause of action for intentional infliction. And number three, the Constitution allows them to remain silent and not have to disclose. I think that's what they're saying here. They're entitled to their legal rights. And a civil action like this one would turn our entire constitutional system and the freedom afforded of individuals in this country, in the United States, on its head. In other words, if you let this case proceed, they're claiming, the Laundries are claiming, you're going to turn the Constitution on its head. And it also infringes on too many fundamental rights that the Constitution provides. That's what the Laundries are claiming here. You go ahead and read through this. I'm just pointing out the new areas because a lot of this was covered in their initial motion to dismiss. Boy, I can't speak. Their initial motion to dismiss the original complaint, but now that it's amended, they had to file a new motion to dismiss the amended complaint. So in response to the original motion to dismiss, the Petitos argued that the Laundries had no constitutional right under the circumstances because there is no state action. If you remember, the Petitos were saying, in response to the Laundries' motion to dismiss, they were saying that the Constitution doesn't apply to the Laundries because there was no state action. In other words, there was no government. It wasn't a law enforcement wasn't involved asking a question. It was just parents asking other parents questions. So they said that because it was private party to a private party and the government wasn't involved, that means there was no state action to trigger the constitutional rights. But that's not what the Laundries are saying here. The Laundries are going to say that state action is involved, and I'll get to that in a second. They're saying as an initial matter, while the Bill of Rights does protect against state action, constitutional rights do not disappear simply because the government has not acted. Rights can be waived, but they always exist, is what they're claiming. Where the dispute is between two private parties, as it is here, two parents, the situations where courts have found a person should have acted, despite an assertion of a constitutional right, is typically in the context where a defendant is bound by a contractual, by contracts, a contract. There's no contract between these two parents, these two families, or other legal duty. Is there a legal duty that one family has to talk to another? Not that I'm aware of, not in this case. And they're saying that's not the case here, as the plaintiffs have not alleged, they've not alleged in that four corners of their complaint, or in the amended complaint, that the Laundries had any legal duty to speak to the Petitos, to speak to Gabby's parents. And they claim, the Laundries claim, there is no legal duty that would require the Laundries to speak to the Petitos. Furthermore, the case does involve state action, is what they're saying. So even if the Petitos claim that the Laundries can't claim their constitutional rights because there was no state action, the Laundries are now saying, no, Petitos, there is state action. Therefore, we have a constitutional right to remain silent, to not speak, to get an attorney. So they're saying this case does involve state action, as the plaintiffs are attempting to secure a judgment from the court, and they say it's regarded as state action because the judiciary is involved. They say the judiciary, a branch of government co-equal with the executive and the legislature, is no less subject to the constitutional strictures against governmental interference in the First Amendment rights. In other words, because the Petitos are asking the court to get involved in this by filing a lawsuit, that amounts to state action. Okay? In Florida, state action is a broad concept, and the actions of state courts and judicial officers performing their official capacities have long been regarded as state action. So here's the Laundries pointing to case law and quoting case law by saying that if a judge basically gets involved in this, then that judge is performing in their official capacity, which amounts to state action. Therefore, the Constitution applies. Therefore, the constitutional rights apply. Therefore, this case should be thrown out because the Laundries had constitutional right to remain silent and to not speak. That's what they're claiming to the Petitos. So you can go ahead and read this. The trial court's ruling, not legislative, is anti-constitutional state action. State action occurs when a state court is called upon to enforce the actions of a private individual, permitted by, not compelled by law. So I'm curious to see how the Petitos are going to say, no, none of this case law applies. And in fact, there was no state action. Are they going to say just by the fact that they filed a lawsuit doesn't trigger state action? Maybe they're going to argue that state action doesn't occur until they get a judgment against the Laundries? I don't know. I'm going to be curious to see, because they're going to be replying. The Petitos have an opportunity to reply, to file a response to the Laundries motion to dismiss that we're going through here. So what do you think they're going to say? No state action? State action? So in making their state action argument, the Petitos conspicuously failed to cite a case where a person in the Laundries position was either compelled or later found liable for exercising their First Amendment right to speak or not to speak. The Laundries were legally permitted to exercise their constitutional rights, and they are not liable for doing so. The tort of intentional infliction of emotional distress is not created by a person who does no more than pursue his or her legal rights in a permissible way, even if he knows or she knows the conduct will cause emotional distress to the plaintiff. So what the Laundries are saying here, again, there's no case law to support the Petitos' argument that the Laundries had to speak up. They had to disclose. They're saying there's no case law to support that. And they're saying that the Laundries, that they had a legal right to exercise their constitutional right to not speak up. Even if them remaining silent caused emotional distress to the Petitos, is what they're saying. Even if not speaking, when doing so, could subject them to criminal penalties. They have a constitutional right not to speak when doing so would subject them to criminal penalties. That's what the Fifth Amendment, the right to remain silent. So once again, the Laundries are pointing out their constitutional right to remain silent. So in response to the motion to dismiss that the Laundries filed regarding the original complaint, the plaintiffs argue that the court should not consider the Laundries' exercise of the Fifth Amendment right to remain silent because they didn't allege in their four corners that it was a criminal investigation that was going on. The plaintiffs did allege that the Laundries refused to respond to either of Gabby's parents or law enforcement, but when they amended their complaint, they deleted that, and I pointed that out to you in the prior video I did. They deleted the law enforcement language. Why did they do that? Because that triggers a criminal investigation, which would trigger the right to remain silent, the constitutional right to remain silent. And they're saying, but they noticeably removed that reference in their amended complaint. Okay, but in all fairness here, I do want to point out that in this motion to dismiss, the Laundries also deleted language from their initial motion to dismiss. And if you look at page 13 in particular of their motion to dismiss regarding the original complaint, they did say the Laundries have a constitutional right to not speak on any topic and a more specific constitutional right not to speak in the face of a criminal investigation. There was unquestionably a law enforcement investigation of the Laundries regarding the disappearance of Miss Petito. Well, that's not in their motion, in the Laundries motion to dismiss that we're looking at. So even though they claim that the Petitos removed law enforcement, the language law enforcement, in all fairness, so did the Laundries. The Laundries removed it because it's in, I'm reading it to you, it's in their initial motion to dismiss. And why did they remove? There was an unquestionably a law enforcement investigation because they don't want to give credence. They don't want to say, they don't want to concede that it was a criminal investigation, therefore triggering the constitutional right. They left it out too. The Laundries left it out. They're not conceding it's a criminal investigation. So, kind of interesting. So, first, the court is permitted to consider reasonable inferences. The plaintiffs do not include the word criminal investigation in their complaint. They do allege that Brian Laundrie was murdered, sent texts regarding the murder, hired an attorney. Therefore, the court can conclude it was a criminal investigation. Therefore, the Laundries had a right to remain silent, even though they deleted that criminal investigation language in this motion to dismiss. I don't, just my opinion here. All due respect to, both counsel. All right. So second, there's no requirement that an individual face a formal criminal investigation in order to remain silent. So the Laundries here are anticipating possibly what the Petitos are going to argue. The Petitos are going to say, hey, there was no formal investigation of the Laundries, therefore the right to remain silent doesn't. You don't have the right to remain silent. Well, the Laundries are saying here, no. You don't need a formal investigation to be underway. You always have the right to remain silent, is what they're claiming here. It's the hallmark of our democracy, if you read this. And that they're free to exercise their constitutional rights without regard to a formal investigation. And then they also claim the Laundries have a right to speak to an attorney. It's the Sixth Amendment in our Constitution. You can go ahead and read through this. A lot of this I covered in the prior video I did on the motion to dismiss. Okay, again, almost here. And again, they're they're adding another case here regarding workplace situation to support their allegation here. Why the complaint, the amended complaint needs to be, and the whole case needs to be dismissed. So they said the plaintiffs had not alleged facts supporting causation. And again, I talked about this in the prior video. This is where a lot of plaintiffs lose their cases because they're not able to show that the conduct of the defendants, in this case, the Laundries allegedly withholding information, that conduct caused the emotional distress. All right, they have to show that it's a direct and proximate cause. Well, they're saying here, as any parent would be, the plaintiffs were distraught about their daughter's whereabouts. But the Laundries did not cause Gabby Petito to go missing or the plaintiff's reaction to the news. So they're saying here that the Laundries are saying our conduct did not cause your emotional distress. The amended complaint alleges that the Laundries could prevent such additional mental suffering and anguish. So even though the Petitos claim in their amended complaint that the Laundries' conduct, they could have prevented additional mental suffering to the Petitos, the Laundries are now saying, well, that's still not enough. That doesn't show that we caused the emotional distress. And if you read what they say here, extreme and outrageous conduct is a legal cause of severe emotional distress. If it directly and in natural and continuous sequence produces or contributes substantially to producing such severe emotional distress. In other words, but for the extreme and outrageous conduct, the severe emotional distress that the Petitos allege, it would not have occurred but for the extreme and outrageous conduct. In other words, the Laundrie's conduct has to directly cause the emotional distress suffered by the Petitos. While concurring causes of distress are possible, it cannot be said that but for the Laundrie's silence, the plaintiffs would not have suffered. That's pretty compelling, I think. I don't know what the judge is going to do with this, but basically what the Laundries are saying here, that even if they were silent, even if it cannot be said that but for the Laundrie's silence, the plaintiffs would not have suffered. So in other words, even if the Laundries were silent, the Petitos, Gabby's parents, would have suffered emotional distress anyway. I think that's what they're saying here. Rather than alleging that the Laundries were the legal cause of the plaintiff's distress, the plaintiffs allege that the Laundrie's silence failed to prevent such additional mental suffering. In essence, this alleges that the mental suffering was already occurring by Gabby's parents, and that the Laundries failed to stop it. And they're saying that the failure to stop distress is not the same as causing it. So even though the Petitos say that they had suffered additional mental suffering, they still have to show that the Laundrie's conduct or silence was the cause of the suffering. And they're saying you can't show that. The failing to stop distress is not the same as causing it. So in conclusion, the plaintiffs say, the Laundries say that the plaintiffs, the Petitos, have not and cannot support a factual assertion that can be supported by evidence which gives rise to legal liability. In other words, even if we all agree that everything that they allege, everything that that Gabby's parents, the Petitos and the Schmidts, allege in their amended complaint, even if all of that's true, that Roberta allegedly blocked Nichole from Facebook or responding to any of her text messages, that they were told by Brian that he murdered Gabby and they didn't tell him, that they went on a vacation with Brian while their daughter was murdered and they didn't tell them about her whereabouts. Even if all of that's true, that doesn't arise to a cause of action for intentional infliction of emotional distress. That's what they're saying. So they asked the court, the Laundries asked the court, respectfully request the court to dismiss the amended complaint with prejudice. And what does that mean? They're asking the court to dismiss, to throw out the lawsuit by Gabby's parents with prejudice. And that means so that they don't have an opportunity to file it again, so that they don't get another opportunity to file another lawsuit to amend this complaint again, so that they sue the Laundries. So what do you think? Do you think this is a slippery slope for the Constitution? Do you think the Laundries had a constitutional right to remain silent, to not speak, to withhold information? Or do you think this is a valid lawsuit of grieving parents, that grieving parents have a right, or anybody else involved in tragic circumstances or hurtful events like this, that they have a right to require someone else to give them information? I don't know. What do you think? I think it's a pretty tough case for Gabby's parents. I really do. I'm going to be curious to see what the court does. So what's going to happen next is that I'm sure Gabby's parents, the Petitos and Smith, have an opportunity to file a response to this motion to dismiss by the Laundries. And I'm sure the court will schedule a hearing so that both sides can argue and the court can make a determination. And yes, it is a novel case. And yes, it is a test case. And the question is, does the Constitution apply, or does it not? So, What do you think? What's your analysis? Because this is simply my opinion, my analysis. So please do leave a comment and hit that subscribe button. Support my work by hitting that subscribe button, hit the like button, and hit the bell notification button. And if you want to contribute to donate to me, helping me create these videos, I'd appreciate it. So I'll put a PayPal link in the description box below the video. So thank you very much for watching. And I'll keep you posted on what happens next. And please do take a look at my prior videos in case you want more information. So thanks again. Thanks for watching.